And the one thing I want to say is, and I said this to Judge earlier, as a defense attorney, you know what you do is in a case like this where the evidence is really against you. You just have to challenge every piece of evidence. And you hope for a weak investigation, some holes in the investigation. This is one of those cases where that doesn't even exist. I mean, they followed this guy and they watched him do certain things. I mean, this is a tough one to wiggle out from under.
He said, what happened? We don't know. And for a very critical juror, this could open the door to maybe the jury discussing, well, maybe it was a fight that went wrong. In other words, maybe he was trying to do some kind of self-defense, but then another discernible juror is going to say, even though he has the right not to testify, the easiest way to show this is he should say his side, but he didn't. So that reasonable doubt becomes a little unreasonable, doesn't it?
So,
but
Silva,
I do think the defense attorney...
I'm sorry, I didn't mean to interrupt you, but I just have to ask you a question at this juncture, because what stood out to me is I felt like the defense attorney, although I find him charismatic, likable, presenting a great closing argument, was simply defining circumstantial evidence. This is a circumstantial evidence case. They don't have a witness who saw it happen. So I felt like, uh-oh, if that's the best you have, it may not play well.
But Judge Ashley, I think in the desperation sometimes of defense attorneys, when we really don't have something viable, we use the best thing we can. If attacking circumstantial evidence is it, then we have to do it. The evidence was incredibly bad on this client, right? And if I put myself in the defense attorney's position, and literally when Court TV gives us the eyes into these trials, that's what I do. I try to imagine what I would argue. And I was kind of proud of this defense attorney for actually doing this kind of argument, because I don't know what else he could have said that is reasonable. Remember, it's not all doubt, it's reasonable doubt. And I just don't see reasonable doubt in this case without attacking circumstantial evidence.
And the way you present it is so key, and I think he's presenting it very well.